All right, ma'am, are you Amy Louise Berg? Do you understand that the state has filed a motion to adjudicate or revoke your community supervision? All right, you have a lawyer, Mr. Hunt. Both the state and your lawyer have asked that this matter be reset to another evidentiary day. And the next available date in this court is January the 27th of 2022 at 1:30 p.m. Do you understand that? And they'll bring you back at that time. All right, anything else that needs to be put on the record at this time?
Not from the state.
Mr. Hunt, anything?
Nothing else, Judge.
All right. Hopefully I'll see both of you back on the 27th of January.
Thank you, Judge.
All right, do we have paperwork yet?
Judge, I believe Mr.
All right, good.
We do.
Mr. Arlater, do you have the judgment?
I have.
You reviewed it?
Yes, Your Honor.
All right. Could I see it? All right, counsel, please approach. All right, is there argument regarding the waiver of appeal?
Judge, state would retract its argument that Mr. Gamel is unable to appeal. I don't believe that that is true. As state would concede, as to punishment only, Mr. Gamel, we do believe, does have the limited right of appeal as to the punishment of this case only.
That's correct, Judge. And we're entitled to appeal under Article 44 of the Code of Criminal Procedure. And for any sentence less than 10 years, 10 years or less, we're entitled to an appeal bond. Judge.
Here's their recommendation from the state as to bond.
Judge, state would recommend $50,000 based on the fact that the defendant has absconded in the past. In this case, we understand that he has limited criminal history, but he has absconded in the past. And there is we believe, substantial likelihood that he will go to prison. That is a substantial inducement to abscond from this jurisdiction once this case is finally resolved.
All right, Mr. Arlater.
Judge, you heard the testimony from today. You've seen what their finances are. You've seen that he has reported dutifully to probation for the last, I guess, since April 30th. My client wants to finish off his rights that he's currently entitled to and appeal this case. And I've counseled him on all of his rights to appeal and what parole would be if he does not wish to appeal, and he wishes to appeal based on the circumstances of what they can afford, Your Honor, based on the fact that He was working and he can continue to be on pretrial conditions of bond, whatever the court would set, or sorry, conditions of appeal bond, whatever the court would set. I feel like a reasonable bond here would be $10,000.
All right, I'm gonna set the bond in this matter, 15,000. And does the probation officer, he's up? I revoked his probation, so it's not on probation. Does the probation officer supervise bond release?
I believe it would, yes, Judge, we have a pretrial release officer that I believe would handle that.
All right, well, I would want him to report once a month to the pretrial release.
Judge, we have a standard set of conditions. You can select the ones that you believe are appropriate.
Well, that's the main thing. I just want.
We can provide, with the probation department can provide the court with
All
that.
right.
And you could, it's a checkbox. You can check whichever ones you believe are necessary.
And Judge, one final thing, I would like to make a motion to withdraw as counsel and ask the court to appoint him counsel for appeal. My client can fill out an affidavit of indigency and see if he qualifies for an attorney. I believe Judge Martin will be the one who reviews that. So upon completion of that, I think
I
that
don't think Judge Martin, he can't.
I don't think he should have any.
He was a witness and
Okay.
he's recused. I'll be happy to appoint an attorney. I can do that over the phone.
Okay.
Fax,
State would suggest if he'll fill out the paperwork, send it to Ms. Patty. She can send it to the court. He can make his determination
Yes, Your Honor.
based on our indigent defense plan.
Yes, Your Honor. I'll do that. And I'll send the court over a proposed motion of withdraw and to appoint counsel, and I'll get the affidavit completed.
All right, Mr. Gamel, I've signed the judgment. I've set a bond, appeal bond of 15,000. Your attorney has notified the court, and it's on the record that you do wish to appeal this matter. And he also has advised me that he is moving to withdraw as your attorney. So you'll have to apply for a court-appointed attorney for purposes of appeal. All right, thank you. That's all in this matter.
Thank you, Your Honor. Your Honor, will you approach?
Yes.
Judge, I just wanted to thank you for your time.
You're on YouTube.
Okay, how do I do that then?
You don't, you have to step off the bench.
Okay, I'll wait for you.
All right.
Straight. Yes, ma'am.
What is the standard cost? Okay, I need to put the bond amounts on. Mr. Merlier. I'm gonna have to ask you this thing.
Yes, Your Honor.
You get his signature, thank you.
Mr. Files, are you ready on Mr. Weldon Lee?
Legal assistance going over paperwork with him
Okay.
now. Now they're changing all of this.
Yes, sir. Thank you. Good afternoon, Mr. Ashmore. Can you hear me okay?
Sure can, Judge. Happy holidays, Merry Christmas. Thank you.
Do you know if you're ready on Brenda Martinez, CR 17240? You want me to call her up? Yeah, you may go ahead and call her up.
Yes, sir.
Ms. Martinez, if you'll come up, please. This is CR 17240. Give Ms. Martinez a chance to make it to the podium. Come on up, Ms. Martinez, so that your attorney can see you.
Hey, Ms. Martinez.
All right, Mr. Ashmore, Mr. Woodwike has tendered to me a motion to withdraw the state's motion to revoke and terminate community supervision. I'm assuming that you are unopposed to that motion.
That is correct, Your Honor. This is the fruit of the efforts of the District Attorney's Office, and we greatly appreciate their position. If the court needs to know, my client was on a 4-year probated sentence. All of her violations were literally at the tail end, at that like month 10, year 3, and they're financial in nature due to inability to work, couldn't afford the deep lung device for a number of days, but was in no way violating any other term of her probation. And the state has agreed to withdraw and terminate, and that would, as we understand it, effectively end her probation and allow her to be released.
So Ms. Martinez is current on all of her financial obligations to the state. She's paid her fines, fees, restitution, of that nature.
I am unaware, Judge. This is Ms. Heisel's case. She's unable to be here, but this was the agreement that she reached with Mr. Ashmore.
Do you know, Mr. Ashmore, if she's satisfied all of her financial obligations?
I don't know if she satisfied all of her financial obligations. I know that before her arrest, she was current on everything. And my recollection is that her motion to adjudicate and revoke had no financial violations, with the exception of failure to pay the DLD, which she couldn't afford, wasn't working. It was the end of COVID. And that's my understanding though, Judge.
All right, so what I'm gonna do is I'm gonna recall your case in just a moment. I need my court staff to confirm for me that you have paid off everything.
If I think I do, I don't know how much.
Okay, just have a seat and we'll figure that out.
All right.
Mr.
Thank you,
Ashmore,
Judge.
I've got, my docket has got a note on it showing that there's a delinquency of almost $2,000. So I'm gonna recall this case and let y'all try to figure that out.
Okay, Judge.
Finish that matter, paperwork, how do we swear to it since he's in custody?
We'll just have the clerk come in here. If you'll just go let Ms. Cassell or Ms. Everett know that you need sworn or her sworn, then they'll come in and come back there and swear. Mr. Adams, you ready? You ready on Hunter Huggins?
Yes, Your Honor, ready to announce.
Mr. Huggins, if you'll come forward, please, sir. All right, this is cause number CR 20124, State versus Hunter James Huggins, set for motion revoked today.
Good afternoon, Your Honor. Mitch Adams on behalf of Mr. Huggins. I was recently appointed to represent him, and I received just yesterday, maybe this morning. I was out of the office when I had a copy of the state's motion to adjudicate. Prior to that, I did have a copy of the violations report, but not the motion itself. I received what I would like to think is a preliminary offer from the state in this matter, neither of which I've had the opportunity to review with my client. I'd ask the court to set us for a contest on the contested docket so that I can do those things. And I'm fairly confident that we'll have this worked out by the time we come back.
Is this our first contested docket on Mr. Huggins?
This is.
This
It's
is
the first time I've been here with this.
Mr. Huggins, how long have you been in jail?
75 days.
75 days. So it's going to be January 27th, so it's going to be another 45 days. It's going to put him over 100 days. And that's what you are asking for.
I am, Judge. I know that Mr. Huggins and I have not been able to have this conversation yet. But I fully acknowledge that he might not like the sound of that. I don't have a choice right now.
All right, court will set Mr. Huggins for another contested docket date on January 27th at 1:30.
And Judge, if we can reach an agreement beforehand, we will let the court know so we can resolve Mr. Huggins' case as expediently as possible.
27. 25 is the docket date, 27 is the evidentiary date.
Can I get your signature? Just to acknowledge that you have a copy of this. Get this worked out before then. That's all I have on the docket this afternoon. Yes, sir. Good to see you.
Mr. Schmidt, are you ready on Mr. Harris? Time to speak with Mr. Woodward.
I've spoken with Mr. Woodward, Judge, I spoke with Ms. Heisel.
Well, if you're gonna make an announcement, let me bring him up.
Oh, okay.
CR 14-494, Robert Harris. Mr. Harris, if you'll make your way to the front, please. Right there, Mr. Harris, podium sponsor. Since your attorney's here, right there. All right, go ahead, Mr. Schmidt. I understand that you filed a motion for continuance of today's hearing, and so I'll allow you to argue that at this time.
Sure, Judge. So I was retained on this case in mid-October, I guess. Mr. Harris had been in custody for some time, but was deemed not to be indigent. And so he had obviously a hard time coming up with money to pay an attorney. Eventually, a friend of the family was able to retain me. I've had an opportunity to meet with Mr. Harris on several occasions. We do have an offer on the table. However, in meeting with Mr. Harris on multiple occasions and going over his background with me, or him going over his background with me, he suffers from a diagnosed mental illness, was a patient of MetroCare in Dallas, which is the equivalent of the Andrews Center, the local mental health authority. Was prescribed and was on medications such as Seroquel and things of that nature. Has not been on those medications since he's been in the jail. An offer has been made. I've talked to my client about that, and although I'm not at a point where I would say my client's incompetent, Judge. I've had some difficulty with him in communicating. I have reached out to the Andrews Center with Jennifer Brashear, formerly she's Jennifer Brashear at the Andrews Center at the forensic unit. She actually emailed me back today and said she'd been in communications with the jail nurse about potentially getting him in front of the doctor because he's not on any psychiatric medications. And so this was set. I was hired the day before the last setting, and it was set on a contested docket, but with the hopes we'd work it out. We hadn't even discussed the case yet. There's an offer on the table, but again, without going into too much for my client, and I'll go into what you want if you need it for purposes of my motion.
Let me cut you off and just say, here's my concern.
Right.
He's been in custody since July.
Sure.
On the state's motion to revoke, and
Sure.
I think it's obligatory on the court to see that the case moves at a faster pace than. If we reset this, it's going to go to the end of January. It's going to be more than 45 days.
Sure.
And that's going to push us a really long time on a motion to revoke.
Sure, Judge. And I understand that. And I would just, again, note that the reason he's been in since July was because he didn't qualify for court-appointed counsel, which oftentimes inmates do. And so he obviously had no resources to hire anyone from July until October. Again, it was, best of my knowledge, a friend of the family who retained me. And so, I understand that the court's concern. He's been in since July, but he's only had a lawyer for, 45 days. I'm not asking for a long continuance. I just I feel like we're almost in agreement, but it's hard to explain, Judge, without getting too much of my details with my client.
I don't want you to do that, but here's my concern. If he doesn't go to a doctor and if he has any kind of mental health issues, he's going to continue to deteriorate. And all I'm doing is exacerbating the situation by resetting him another 45 days. And I'm afraid that the longer he sits there, that maybe the next announcement I get is, Judge, I believe he's incompetent. We could have pled him out back on December 2nd, but now I believe he might be incompetent, and pulls the trigger that I've got to have him evaluated. And then, he may find himself in a mental health situation where he's trapped in the jail, with no right to get out and no bed availability at a mental health hospital and no ability to do outpatient rest. That's my concern. That's what I want to talk about today, but I don't want you to disclose anything other than if.
What I would disclose to the court is that he's been diagnosed since he was 18, with bipolar disorder. I can't even remember the And has been in continual treatment, has a long family history of the same illness. And again, I don't anticipate this going down the road to competency or incompetency, Judge, because, and I will tell you, I'm not trying to delay this. I mean, just so you know, I mean, all obligations that my client has to me are over. I'm not trying to push this off. I just assume get it over with today. But I've dealt with enough mentally ill people to know when, or those who claim to be mentally ill, you know, who I think are malingering, and I wouldn't bring this issue before the court if I didn't think there was a significant issue with my client as to his sort of paralysis to make a decision, I guess is what it is. And I truly think that's based upon the fact that he has not been in front of a jail doctor to see if they can get him on mood stabilizers, which he was on previously. Ms. Brashear, formerly Jennifer Graham, the Andrews Center, spoke with the jail nurse, and he's on nerve medication, but has not been in front of the doctor to be evaluated. Anecdotally, I went to the family and asked them to get me a release from MetroCare so that I could get those records, so that I get those to the jail, so perhaps he could get some treatment. They've been unable to get those to me. So I'm sort of, that's why I reached out to Jennifer Brashear now at the Andrews Center, seeking her help and advocating for some sort of mental health evaluation by Dr. Montgomery, who I believe is still the jail doctor here. And she reached out to me, back to me today, actually earlier, and said she'd gone back and forth with the nurse. And that's kind of where we are, you know.
So you believe that there's a potential that he gets a mental health medication that allows him not to have decision paralysis on whether or not he accepts the state's offer?
Yeah, I mean, I guess that's yeah, I mean, that's what it is. That's sort of, yeah, I mean, that's a good way of putting it, even though it's not really clinical terms. I agree with what you're saying exactly. Yes. And I don't think he's, you know, trying to put it off for, you know, any reason. He's miserable in this jail. He doesn't want to be in this jail either, Judge. You know, do I think that, you know, if he was to take the state's offer, he would be getting perhaps, you know, better mental health treatment? I do. But, you know, I mean, I just don't think it's because, I don't think he's just, and that's why I say I don't think he's malingering in this sort of paralysis, because what I think is best for him and what is something I think he's just not quite understanding. And it's hard to explain if you hadn't, you know, been privy to our conversations and privy to our phone calls and privy to my conversations with family members.
What happens if I reset to the 27th, but he doesn't get prescribed anything?
You know, I don't know. I mean, what
It would seem to me if I did that, then the only position I'd be in is either he's competent to go forward and we go forward, or he's incompetent and I'm not able to go forward, but he doesn't get to not make a decision. You know, so
Sure.
I mean, there's no guarantee that he's going, one, that he's going to get medication, or two, that the medication is going to be effective.
Sure.
I understand the situation that you're in. And I know you're not delaying. I know you're not doing that. But my concern is on the counter of worst case scenario. He never makes a decision, and we're just resetting, and it doesn't improve your position. Your position won't change.
Well, and frankly, an incompetency position wouldn't improve his position on a case where he's facing a maximum of 10 years non-aggravated, where he has almost 6 months credit back time with the offer the state is making. Without revealing that, I mean, I guess what I'm saying is he's in delaying this today, in my opinion, does not benefit him. Okay. You know, what my opinion is, however, I think the mental health issues that he is addressing are so to the forefront that he's just not right there. I get in this. I'm walking a fine line.
No, I understand. But as I said before, though, if he becomes incompetent,
I understand.
He may be sitting in the jail longer. You know, he can't sit in the mental health hospital any longer than the sentence
Right.
that he can get. But he would be, his mental health would be treated or improved sitting in the county jail. And so understand that it doesn't benefit him, but it may in fact be the opposite. He may be stuck waiting for a bed at Terrell State where we've got inmates that are in the 400s. They're number 400 and something. So it's safe to say that he's going to be behind 400 other individuals waiting in the county jail where he's not going to be getting mental health treatment. He may be on medication, but he's not getting treatment.
Yes, sir. No, I understand. I mean,
And I want to avoid that.
oh, I do too. I mean, and technically he could serve 9.5 more years in the county jail or in Terrell State Hospital. You know,
Is that so? He's what, third degree? Is this a true third?
it's a true third.
And what's the state's offer today?
It's 4.
Or imbalance of financials.
This feels like I'm bidding against myself. Feels like if I make because I want to err on the side of deferring to counsel.
Right.
For obvious attorney-client conversations and relying on that privilege and trusting you as an officer of the court and a well-reputable attorney, both in the courtroom and out the courtroom. But I feel like I'm bidding against myself in that he's likely going to continue to deteriorate, and I'm going to find myself spending more tax dollars getting him evaluated and then holding him here when maybe the decision could be made today, even without his decision.
And I'll tell you what, Judge, could you repeat one more time if, and I understand it's a big if you were to grant a continuance, it would be set out until January?
That's the next available contested docket due to the holidays.
So my client needs to know that if we didn't resolve it today, there'd be another 2 months in the county jail before anything would happen, essentially. So with that being said, could I perhaps have a few minutes to visit with my client
Absolutely.
and talk to him about some recommendations on behalf of this offer, oral eligibility, things of that nature?
Yes, sir.
Thank you, Judge.
According to the court, our paperwork is filled out, whatever the court's ready for.
I'm ready, Mr. Files. You have that? Well then, Lee.
Podium is gone. Where do I say?
Wherever you want. You got privileges. You can sit up here by me if you want.
I always ask permission rather than forgiveness.
Sir,
I always ask permission rather than forgiveness.
you've been married. How many years you been married?
59.
And there's a reason, right? Mr. Lee, you are Weldon Kenneth Lee, right? Yes, sir. Mr. Lee, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, you may put your hand down. All right, Mr. Lee, you appeared before this court on September 29th of 2020. You pled guilty to the offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. Court admonished you, accepted your plea of guilt, and then assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice. Court then suspended your sentence, placed you on community supervision for a period of 4 years. It was during that period that the state filed a motion to revoke your community supervision, and they have alleged in 12 separate counts ways that they believe that you have violated your community supervision. Have you had an opportunity to review that document with your attorney, Mr.
I have, sir.
Files?
I have, yes, sir.
If you'd like,
The state is abandoning counts 1, 2, and 10. The evidence against the defendant in this case arises out of the offenses of Texas. We agreed to enter pleas of guilty to a third-degree felony drug charge, a state jail drug charge, and a 1245 the weapons charge, which is repeated in counts 1, 2, and 10 this. So since we are not pleading to that in Wood County, we are the state has agreed to all their abandon those counts in the indictment.
okay, you said those are Wood County offenses that were alleged.
They're all Wood County offenses. They're alleged in 1, 2, and 10. State is agreeing to abandon 1, 2, and 10.
Okay, thanks, sir.
Thank you, Your Honor.
So, Mr. Lee, have you had enough time? Do you believe you've had enough time to review these allegations against you with your attorney, Mr. Files?
I have, sir.
Mr. Files, does your client waive the formal reading of the state's motion for a vote?
Yes, Your Honor.
And now I know it is his intention to plead true to counts 3, 4, 5, 6, 7, 8, 9, 11, and 12.
That's correct, Your Honor.
All right. And Mr. Lee, are you pleased with Mr. Files' representation of you?
I'm fine with it, yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Negative.
And Mr. Files, you believe your client to be competent today?
I think that he is, Your Honor.
You explained to him his legal rights, and do you believe he understands them?
I have, Your Honor.
I see here that the agreement is that Mr. Lee is going to plead true to the counts that have not been abandoned. The state's recommendation is that upon a finding of true that his community supervision be revoked and that he be sentenced to 4 years confinement in the Texas Department of Criminal Justice with a balance of his financial obligations, which includes your previous fines, restitution, and court costs, and that you would receive 82 days credit towards your sentence for the time that you have spent in jail in this cause. Is that your understanding, Mr. Lee?
Yes, sir, it is.
Yours as well, Mr. Files?
It is in Wood County, pleading for a 4-year count, a 6-month state jail count.
Okay. All right, so Mr. Lee, then at this time, I'm going to ask you, do you plead true or not true to counts 3, 4, 5, 6, 7, 8, 9, 11, and 12?
I believe that's true, sir. Yes, sir.
And are you pleading true to the conduct alleged in there because the conduct alleged is true?
Yes, yes, sir.
Has anyone threatened, forced, or pressured you to plead true to any of these counts?
Negative.
All right, court will accept the defendant's pleas are true. Any objection to the state's evidence, Mr. Files?
No, Your Honor.
State's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
The defense?
And perhaps consider, Your Honor, we believe it would be in his best interest and society's best interest to participate in such drug treatment in the penitentiary if it would be available. And would ask the court to recommend that such treatment be made available to him.
Is there a finding that I can make in this judgment, or is there a separate judgment that goes down with his pen pack? I mean, I don't mind making that recommendation.
You can make the recommendation, just interlining.
Well, see, the problem with TDC is anything that I write, that any handwritten part of the judgment, they're gonna have a problem with.
We'll be happy to addendum to the judge.
Okay,
State would be obviously unopposed to any reasonable orders that Mr. Files' office would present to be attached to the judgment for such treatment.
We'll send it to Mr. Woodward for his signature, and then you can present it to the board.
I would be happy to.
or you can just e-file it. If you want to e-file it, then that'd be fine as well.
Yes, Judge.
All right, anything further, Mr. Falls?
No, Your Honor.
All right, then based on the evidence presented to the court finds that Mr. Lee has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. Court finds his pleas to be true. Court revokes his community supervision, assesses his punishment pursuant to the plea agreement at 4 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders him to pay the balance of his financial obligations. Court awards him 82 days credit towards his sentence for the time that he has spent in jail on this cause. And the court will make the recommendation that Mr. Lee be enrolled and have an opportunity to participate in any of the drug treatment rehabilitation programs operated by the Texas Department of Criminal Justice. So the courts made that recommendation, and the court will sign any order reflecting the same that's followed by the courts.
Thank you, Your Honor.
That way we can ensure that it goes down in his pen pack. So the quicker that gets sent in, the clerk's office will start assembling that pen pack almost immediately. So the faster that that's done, the more likely it's to ensure that he gets that recommendation.
We will send it over no later than tomorrow before that.
Thank you, sir. All right, Mr. Lee, I'm going to sign your documents here. All right, Mr. Lee, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward here with my deputy to be fingerprinted. Any further, Mr. Collins?
Matt Rhodes.
You may.
Thank you, sir.
Just going to make an announcement regarding Mr. Elder's case. Mr. Stevens is in Kaufman County and he is on his way over. So as soon as Mr. Stevens gets here, then I'll call Mr. Elder's case. So just want to let you know what's going on. Okay. This is cause number CR 14494. Mr. Harris. You do me a favor, sir, raise your right hand and place your fist. Sir, do you swear that the testimony given before today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
May you choose. All right, you are Robert Dustin Harris, is that right?
Yes, sir.
Mr. Harris, you appeared before the court on August 22nd, 2017, and pled guilty to the third-degree felony offense of assault on a family or household member with a previous conviction. The court heard the evidence, found you guilty, set your punishment at 10 years confinement in the Texas Department of Criminal Justice. The court suspended your sentence that day, placed you on 4 years of community supervision with probation, and also ordered you to pay a $1,000 fine. It was during your period of community supervision that the state filed a motion to revoke and an amended motion to revoke your community supervision. And Mr. Harris, they have alleged in here's 8 separate counts of ways that they believe that you have violated your conditions of community supervision. You had an opportunity to review that document with your attorney, Mr. Brian Schmidt.
Yes, sir.
But you've had enough time to talk about the case and have all your legal questions answered.
Yes, sir.
Is there anything about this paperwork that you've read, signed today, or what we're doing for today that you do not understand?
No.
You feel like you understand everything?
Yes.
Do you have any questions at this time?
No, sir.
Mr. Schmidt, does your client waive the full reading of the state's amended motion to revoke?
It would, Your Honor.
And does it intend to plead true to all counts?
It is, Your Honor.
I see the plea agreement that Mr. Harris has negotiated with the state is that upon his plea of true to these counts, the state would be recommending that his community supervision be revoked, that he be sentenced to 4 years confinement in the Texas Department of Criminal Justice, and that he pay his financial obligations, which at this point is $50 court cost. Is that your understanding of the plea? Yes, Your Honor. Do you believe Mr. Harris to be competent today?
I do, Judge, and just for the record, if I may, so articulate something I've articulated in my motion for continuance earlier. I filed a motion for continuance based upon my client's mental health condition, and although I do have concerns about his mental health diagnosis being untreated in the jail, that being bipolar disorder, I do feel that my client is competent, and so stated actually in my motion for continuance. I've been able today to talk to my client about the rule on my motion for continuance. I was able to visit with my client and explain to the court that if the court denied my motion for continuance, that our next setting would be 2 months away, and he was able to rationally come to a decision regarding the 4-year offer based upon the time credit that he has. So I do believe that he is competent, and I believe that that sort of paralysis stated seemed to have broken once that came about. I do.
Mr. Harris, will you please, with Mr. Brian Schmidt's representation of you?
Yes, sir.
You're asking the court to approve this agreement today. Right, so at this time, Mr. Harris, I'm going to ask you if you plead true or not true to counts 1, 2, 3, 4, 5, 6, 7, and 8. Are those counts true or not true?
True.
Mr. Harris, are you telling me that those things are true because it is true that you committed the conduct in these counts?
Yes, sir.
Has anyone threatened, forced, or pressured you, Mr. Harris, to make you feel like you had to be true today?
No, sir.
All right. We'll accept Mr. Harris's plea of true to each of the counts alleged. Mr. Schmidt, is there any objection to the state's evidence?
No, Your Honor.
Judicial notice, Mr. Harris's judicial confession in this state's evidence. Any further from the state?
No, Your Honor.
That's Mr. Schmidt. No, Your Honor. All right, the court has reviewed the state's amended motion to adjudicate. Court will find that Mr. Robert Dustin Harris has violated the terms and conditions of his community supervision. Court will follow the plea agreement in this case. I will say, Mr. Harris, that Mr. Schmidt has done you a fine job. I think this recommendation that he's been able to get the state to agree to is probably on the light side. So I think that you talk about plea bargains, and I think this, in the truest sense, is a plea bargain. I think you're getting a great benefit today from this. I'm sure that the court would have granted you a 4-year sentence. You understand? Sir. However, because you have worked with Mr. Schmidt has worked on your behalf with the state, I am going to follow the plea agreement. Thank you, sir. What you asked me to do. The court will follow the plea agreement. The court hereby finding that he is violating the terms and conditions of his community supervision. The court finds all counts to be true, revokes the community supervision of Mr. Harris. The court sentences him to 4 years confinement in the Texas Department of Criminal Justice Institution Division. The court ordered him to pay the remaining $50 financial obligation. Words, is this the correct offense language? 153 days. It is, Your Honor. The court will award Mr. Harris 153 days credit towards his sentence for the time that he has spent in jail previously on this cause.
Thank you, Judge. May you have a seat, or do you need a thumbprint?
I need a thumbs up that sign here. That needs a patient right here, right back. Look like I need you to sign here. Sheriff's going to figure out the terms and conditions of the sentence. Bates going to come and get your fingerprint. Good luck to you, sir.
That concludes my business today. No big excuse.
So that's what they say.
Thank you, Judge.
Like you can bring Mr. Ashman in on Ms. Martinez.
Yes, Judge.
Updated picture of your boy. Hadn't seen him in a while.
Hair down to here.
I bet so.
I don't doubt that.
Ms. Martinez, if you'll make your way up, please. All right, we are back on the record, cause number CR 17240. For the record, Mr. Ashmore is appearing via Zoom today. Mr. Ashmore, you see and hear me okay? Okay, if you'll unmute your device, there you go.
Yes, Judge, I
right.
can.
All right,
Can
do we
y'all
have
see me?
Yes, we can see and hear you. And Ms. Martinez, can you see Mr. Ashmore? Okay. All right, any update? The court had inquired about whether or not Ms. Martinez had complied with all of the conditions of her community supervision. I think there was a question about the financials that were ordered by the court. Do we have any update?
Yes, Judge, I've spoken with the community.
Right. Right.
Go ahead, Mr. Woodwhite.
Thank you, Judge. It's the state's understanding Ms. Martinez owes about $2,000, just short of $2,000. I've spoken with Ms. Heisel, who is unable to be here today. It's her position that the state is comfortable with proceeding to re-urge our motion to dismiss based on the circumstances of Ms. Martinez, and that she was doing what she was supposed to up until she lost her employment with the COVID pandemic, and otherwise we believe she would be able to If the court is not inclined to grant our motion to withdraw and terminate, the state would be asking to reset this matter to another date. So Mr. Ashmore and Ms. Heisel can continue to negotiate this, but in the interim, we would ask, the state would move to set her a bond, likely a PR bond, such that she could get out and not remain to be incarcerated. And in that case, it's likely that she could work to find employment, maybe make some headway on her probation fees / court costs and fines, and thus be able to resolve that, and then likely be able to come back before this court and present that she no longer owes any money, and the state would be willing to withdraw and terminate at that time.
Mr. Ashmore, do you want to join or add or anything?
Yeah. Judge, thanks for the time to work this out. Ms. Heisel's not there. Mr. Wack is in between Rockwall Courthouse and the office. And so I appreciate the court's graciousness today with the strangeness of this hearing. We would join in that motion. Ms. Tabram informed me she does owe $1,967. And again, you know, these are financial hardship issues, not thumbing. Miss Brenda is not thumbing her nose at the court's orders or her agreements with the probation department. We'd ask the court to consider those respectful requests by the state of Texas and Miss Martinez.
In reviewing the state's motion that was signed by Ms. Heisel, I mean, there's multiple violations that have nothing to do with financials. Failure to report, failure to do community service, failure to pass in-home deep breath analysis. She didn't report for, what's alleged by the state is that she didn't report for May, June, or July. So I'm not feeling very compelled to release her in hopes that she's going to start complying with the conditions that she was already, don't say anything, that she was already given. And it doesn't appear to be just technical violations to me. I mean, it is money, but there's more than that. There's no community service going back to 2018. So I'm going to, at this time, I'm not going to grant the motion to withdraw, the motion to revoke, and terminate community supervision because she's not held up to comply. She has not complied with all the conditions of community supervision, and I think that would set a poor policy in the court. And I'm not going to grant a PR bond for someone who stops reporting to the Van Zandt County Community Supervision Department. If she were reporting and doing community service, then I think that'd be a more compelling argument to give her a PR bond and allow her to work. I understand losing your job is an issue with financials, but in my experience, the Van Zandt County Community Supervision and Corrections Department go above and beyond to work with everyone. And if it's just a money issue and not a failure to report or failure to do community service or violations for some type of deep lung analysis, I see that this is a driving while intoxicated charge. Court is not comfortable with granting the withdrawal of the motion or granting a PR bond. So what I'm going to do is, I mean, we are set for a contested hearing today. I understand state's not ready. I understand defense is not ready. So I'm going to set this for another hearing on January 27th. And if there's an agreement that's reached between now and then that satisfy the compliance with conditions of community supervision, you'll let me know and we'll get on the docket sooner.
Yes, Judge.
January 27th. Yes.
All right, Mr. Ashmore, is that all that you have today?
It is, Your Honor. May I be excused?
Yes, sir. Thank you. I appreciate it.
Thank you, Judge. Merry Christmas.
Merry Christmas.
Any update on Mr. Stevens? They told me he was en route about an hour ago.
I'll bring you right up.
Oh, okay.
You can bring him up here, Aaron. This is CR 21-112. State versus Raymond Reese Elder. We are set today on status hearing on competency. Court finds that Mr. Elder was evaluated for legal competency that was on the suggestion of the defense. Is that correct?
Yes, sir. My suggestion.
And so the court ordered Mr. Elder to be evaluated by Dr. Timothy Ingram, and he was in fact evaluated, and Dr. Ingram has provided this court with his findings and a report filed November 15th, 2021. And in that report, the doctor has indicated that he believes that Mr. Elder is competent to stand trial at this time. Mr. Stevens, have you been given a copy of that report?
I have, Your Honor.
And have you reviewed that report?
I have, Your Honor.
And Mr. Woodwhack, on behalf of the state, you two have also received that report.
That's correct.
And you've reviewed that report.
Yes, sir.
All right. And so at this time, Mr. Stevens, is there any objection to the report of Dr. Ingram, or any request to have Dr. Ingram brought to a hearing to question him as to his opinion?
No, Your Honor, we would. We'll agree with his report, and we're not going to require the doctor to come in and testify.
And so you've had conversations with Mr. Elder, is that correct?
Yes, sir.
You have seen Mr. Elder at a time when you believed he was incompetent.
Yes, sir.
And you have now spoken with him, and you have no objection to the report of Dr. Ingram in his opinion that he is competent. Have you had a different ability to converse with your client now after the reintroduction of mental health medications to Mr. Elder?
Yes, sir, I did. I went and visited Mr. Elder in the jail toward the end. I don't have the exact date, but it's toward the end of October. And he seemed so completely a different man, completely. He understood who I was. He understood what was going on. He was very logical. He made sense. And I do believe that he was probably just off his meds, Judge, at that time, but he seems very lucid and completely understands what's going on.
Mr. Elder, are you feeling better today?
Yes, Your Honor, I am.
Good, excellent. I'm glad to see you in a better state. I'm glad to hear this report, Dr. Ingram. Glad to hear this report from Mr. Stevens. So at this stage in the prosecution, then let's go ahead and arraign Mr. Elder today on his charge. Mr. Stevens, you may proceed.
Thank you, Your Honor. If I please the court, I've shown the indictment to my client. He understands the nature of the consequences of the charges. He states that his name spelled correctly, and we will waive reading in the indictment and enter a plea of not guilty at this time.
All right, court will find that Mr. Elder has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. And we will set this for purposes of pretrial. Mr. Stevens,
Yes,
I believe
sir,
that you were
please.
back on January 6th.
Yes.
We could do January 4th or January 6th. 4th, I have a jail docket only setting. If Mr. Reese if Mr. Elder is still in custody, we could do it on the 4th if that's better for you. But if you're here on the 6th, I noticed that my 6th date, I think I've got we're nearing 70 cases that day, maybe a little bit longer. The 4th, I only have 6 cases.
Judge, I could do the 4th, but my problem is that I'm in Kaufman at 1:30 also. So it could be like 3:30 to 4 o'clock before I got here again.
We can
But
set it.
whatever the court prefers, Judge, I'll do.
We'll set it to 6.
Okay,
That
Yes,
means you'll be more readily available.
absolutely.
All right, so we'll set Mr. Elder then for pretrial on January 6, 2022 at 1:30. If Mr. Elder does make bail in this case, then all hearings will be at 9 a.m.
All right, Judge.
You can let him come up to the bench there.
Okay, Judge. Signature right there, and I'll give you a copy of this, and I'll visit with you. I'll have to file a motion for that bond, okay?
there's no way I can make even 5% of that dollar
I understand.
when mother's working for, she's taking care of her mother-in-law who's dying.
Okay, I'll go visit with you.
Yes, you may. Thank you.
Thank you.
Good to see you, Sheldon.
Sure, absolutely. I didn't have it on my docket. He said, are you like on the way over here? I said, no, I'm going to call.
All right, I believe that's going to conclude our docket for today. Mr. Woodward. All right, thank you, sir. All right, so we will be.
Let me run and get this.
Okay, yes, we'll be adjourned this time.